Be ready. Start. Learned advocate Mr. M.G. Doshit, appearing on behalf of the respondent board, has submitted that the board has already filed affidavit and merits has already been disclosed by the respondent board in said reply. However, Mr. Doshit has submitted that award passed by the Labour Court is perfectly legal and valid, and no error has been committed by the Labour Court while rejecting the reference of the petitioner. Mr. Doshit, learned advocate, also submits that this court is having very limited jurisdiction under Article 227 of the Constitution of India, and this court cannot interfere with the award unless any jurisdictional error is pointed out before this court committed by the Labour Court. He also submits that the petitioner workman has not completed continuous service within the meaning of Section 25B of the Industrial Disputes Act 1947, as periodical appointments were given, and thus every appointment amounts to new engagement of the petitioner workman, and in between there was break, and in some cases the break was for 1 month or so, and therefore such working cannot be considered to be continuous service of the petitioner workman. Mr. Doshit, learned advocate, also submits that if the petitioner workman has not worked continuously and completed 240 days continuously, then there is no need to comply with the provisions of Section 25F of the Industrial Disputes Act 1947. He also submits that relationship of employer and employee is required to be established on each occasion, and if the workman is appointed temporarily or ad hoc basis, then there was no obligation on the part of the employer to provide work continuously. As and when work was available, the workman was appointed on the post in question temporarily, and therefore he was not in continuous service, meaning thereby not rendered continuous service with the respondent board. Mr. Doshit also submits that service of workman has been terminated by efflux of time, and there was no question of termination of service by the employer, but employment automatically came to an end as specified in the appointment order was operated. He also submitted that Sankheda project work was carried out by the board and the work was over in 1988, and therefore services of the petitioner workman has been terminated rightly by the board. Mr. Doshit has also submitted that rural electrification program, which was financed by Government of India, and on that basis work was carried out by the respondent board. This group of 52 appeals arises out of as many suits filed in the City Civil Court, Ahmedabad. They were filed by shareholders of corporate employers in which they challenged the wires of Sections 3 and 6A of the Bombay Labour Welfare Fund Act 1953 and Rules 3 and 4 of the Labour Welfare Fund Gujarat Rules 1962. They contended that the aforesaid provisions were ultra vires Article 19 bracket 1 clause F and Article 31 bracket 2 of the Constitution of India. Some of the suits were instituted in 1975 and others were instituted in 1976. No evidence was led in the suits. They were decided on the basis of legal arguments advanced before the learned trial judge. On 2nd September 1978, they were decided by the learned trial judge by a common judgment. He turned down the contentions raised by the plaintiffs and dismissed the suits. Decrees passed by him in all the suits are challenged by the plaintiffs in these appeals. Before we enter upon the examination of the contentions raised by the plaintiffs before us, it is necessary to set out the history of the litigation relating to the impugned provisions. The Bombay Labour Welfare Fund Act 1953, hereinafter referred to as the Labour Welfare Act for the sake of brevity, was enacted by Bombay Legislature in 1953. Section 3, as it was then, was challenged in a group of writ petitions before the High Court of Bombay on the ground that it was ultra vires Article 31 bracket 2. Section 3, as it was then, read as follows: there shall be constituted a fund called the Bombay Labour Welfare Fund, and notwithstanding anything contained in any other law for the time being in force, the sums specified in subsection 2 shall be into the fund. The fund shall consist of all fines realized from the employees, all unpaid accumulations, any voluntary donations, any fund transferred under subsection 5 of section 7, and any sum borrowed under section 8. The sums specified in subsection 2 shall be collected by such agencies and in such manner, and the accounts of the fund shall be maintained and audited in such manner as may be prescribed. Section 7 bracket 1 provided the fund shall vest in and be held and applied by the board as trustees subject to the provisions, and for the purposes of this act subsection 2 of section 7 provided as follows: without prejudice to the generality of subsection 1, the monies in the fund may be utilized by the board to defray expenditure.